car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending your Sunday evening with us. Our topic of conversation tonight is designed to deal with issues that matter to you. So for the next half hour, we've got a couple of experts here with us that are going to be taking your questions. For you to join the conversation, you can call, text, and email. That information is displayed at the bottom of the screen all throughout the program tonight. Also a reminder that there are attorneys standing by right now to speak with you. So when you pick up that phone and give them a call, an opportunity that Hollis Wright extends to you to get some free legal advice. So take advantage of both of those opportunities tonight and join the conversation. Our conversation tonight is led by Carter Clay of the firm Hollis Wright. Appreciate you being with us. It's going to be an interesting topic of conversation tonight.
Yeah, good to see you, David. We're going to be talking about driving under the influence of alcohol, narcotics, prescription drugs. Those instances still plague our society all too frequently. Oftentimes they can lead to tragic consequences, not just being the individual who was driving under the influence being charged with a crime, but oftentimes it results in somebody else getting killed or catastrophically injured, which can ruin their lives entirely. And so it's something that we need to continue to address. It has been addressed through public awareness and education over the years, but we just have to continue to stay on top of it, especially educating teenagers about the dangers of driving under the influence of alcohol. Statistics recently show that in 2014, there were over 14,000 arrests involving driving under the influence and over 9,000 convictions just in the state of Alabama. So it is still rampant. We hear about it, we read about it a lot of times in the news with tragic circumstances. And we're very fortunate here tonight to have a distinguished guest with us, Warren Freeman. He's here tonight. He practices out of Cleburne County, Calhoun County, Alabama. Been doing it for over 20 years. He's developed not only a niche in the area of driving under the influence, but also representing individuals who have been charged with capital murder. So we'll need to get him back at another time to talk about the homicide laws and murder laws and things like that in the state of Alabama. But Warren, we're really glad to have you here this evening. Thank you so much for joining us.
Thank you for having me.
Yeah, tell us a little bit about the nature of your legal practice in Calhoun County and Cleburne County, how you got involved in defending individuals who were charged with DUIs, and also the capital murder practice.
Well, I primarily do criminal defense. I also do auto accident cases, and being out in the country where I am, you end up gravitating toward some probate cases and sometimes a nasty divorce, which I just soon have a toenail removed, I think, to do those. But I've always wanted to be a criminal defense lawyer. I think I told somebody one time, I think it goes from watching too much Perry Mason when I was a kid. But I went to law school with that in mind. I was fortunate to have a murder trial about 6 months after becoming licensed, and was successful with that and enjoyed doing that. And people look at me a lot of times and say, how in the world, Warren, can you possibly represent people that are charged with terrible things? And I remind them that we have rights in this country, and thank God we're in the nation that we are in, and right now we're in the middle of a political debate, and obviously there are differences of opinion as to where those rights are and what rights we should have increased or decreased. But our rights under the Constitution that guarantee you and I and you, David, the right to freedom of speech, the right not to incriminate yourself in something. Those are real substantive rights, but they're no good if you don't protect those even with the lowest of the lowest, I call it, the people that are charged with the most terrible things. Those rights have to be protected for them, or we don't have any.
Right, and one of the things that I always explain to people is, and we see this in the newspaper all the time, is that not only do they have rights that need to be protected, we need to make sure that they're not taken advantage of, that individual prosecutors, law enforcement agencies, police officers are not abusing their power and charging individuals or overcharging individuals with a crime that really doesn't meet the conduct. And we want to make sure that if they are punished, if they are penalized or sentenced, that that sentence is consistent with the crime that they actually committed. And I think you would probably agree with that concept.
I would agree. And you know, 90% probably of what I do in the criminal defense world is making sure that the punishment fits the crime. Now, obviously, I'm not trying to prosecute. I'm defending. But in the process of defending, I'm looking at checklists of is the prosecution meeting their burden of proof? Have they met the burden of proof for whatever the crime is? And you make sure that's done. And then you make sure that whatever punishment, after you've done that checklist, you make sure whatever punishment is appropriate. Right. And that's how you're defending your client, making sure that they're taken care of in the process.
In terms of driving under the influence, where are we as a society in terms of trying to reduce the number of instances of DUIs? And in your mind, is there something more that we could be doing or that we should be doing that would make a positive impact on lessening the number of DUIs?
Well, you know, of course, that the penalties have just increased dramatically in the last several years. And when someone does get convicted of a DUI, it has severe ramifications, as you were talking about in your opening. It can affect their job, it can affect their insurance. There's tremendous cost just to getting a first-time DUI. There's a lot of cost involved. And all of that, I'm sure, has affected the amount of people who want to drink and drive. One of the best things, though, that to me that the court systems have implemented of late is the pretrial diversion programs that are available now in most jurisdictions. And this allows somebody who has made a mistake, or maybe he's had a few too many, and they're out. They find themselves out on the road. They find themselves getting arrested and charged with DUI. It gives them the chance to not have a conviction on their record. And of course, now with our expungement law, which we finally got, the legislature gave us last year, we have the chance then for them to get that removed from the arrest, removed from the record, everything removed. So it's a chance for somebody to get their life back if they've made a mistake. But those are some of the big changes I see in DUI.
Go ahead, Dave.
We're about to have to take a break, but we'll pick up there. We got a question coming up about what do you do whenever you're pulled over, and what questions to answer, and consent to search, and those two. We'll step aside for a break, but we come back. How about if we pick up right there?
Sounds good.
Sound good? All right, we'll step aside our first break of the evening, but time enough for you to get your questions into us. Call, text, email. Would love to hear from you. We do our best to really make it easy for you. Also remember, an attorney standing by to speak with you right now. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis, Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Really try to stiffen those penalties to get your attention. Welcome back in to the attorneys. We appreciate you being with us tonight. A question we've got here for both of you. When an individual is approached by a police officer, the question here, am I required to answer questions by the police officer? Question 1, and what if they ask for consent to search the vehicle? Must I give that to them?
First of all, you need to respond with your name.
Right.
If you ask where you live, that's fine.
Insurance, I guess, proof of insurance.
Proof of insurance, yes. License, of course. Right. You know, beyond those biographical questions, who you are, where you live, car ownership, or you know, right, the insurance card and all that kind of thing, those are fine. But you do not have to answer anything else. And understand that whatever you say is going to be used against you if indeed there ends up being an arrest for a DUI or for some other crime.
And how about consent to search?
No. And the answer is no, and I'll say it again, no. I always tell anybody who ever asks me that question, you need to say, just tell them that your lawyer told you to tell them to get a warrant. Go to a judge, get a warrant. If they've got enough probable cause to search, they can go get a warrant. Right. You do not have to get, and I would, if I left this studio right now and a police officer stopped me and said, Mr. Freeman, do you mind if we search your vehicle? The answer is no, get a warrant. You don't, and I don't have anything illegal in my car.
Right.
So, and people have said, well, it makes me look guilty if I tell him no. I can assure you that's not going to affect things down the line. What may affect it is giving permission to search and tying my hands when there is something that's found that a passenger left in the back seat that you didn't have any idea was there. Right. You've tied my hands to a great degree because you've given permission to search a vehicle that officer had no right to, no probable cause.
Warren, talk a little bit about the legal limits of consuming alcohol, the criteria that is in place for an officer to make an arrest. Talk a little bit about that in Alabama.
Well, there are two ways to be charged with a DUI, driving under the influence in Alabama. The first one, let's talk about. If you have 0.08% or more blood alcohol content in your bloodstream, then you are considered to be impaired. You are not considered by statute to be capable of operating a motor vehicle. Now, how do they determine if you've got that in your bloodstream? They ask you generally to blow into a breathalyzer. And that's done in generally 2 places in the DUI arrest. The officer, first of all, will ask you to get out of the car. He'll ask you to submit to what's called a field sobriety test. And I know probably all of you have seen or heard about those kind of things where you have to stand on one foot, touch your nose. Officer has a light and looking in your eyes. He may ask you to count backwards while you stand on one foot, and I can't do that on a flat surface here. So I don't know how anybody can do that out on a gravel road. But you do not have to submit to that. You can say, no, I do not want to. I'm sorry, I don't want to. A lot of people I've had people call me and they've got bad legs, and they said I couldn't stand up, and I would say, you should have told the officer that and denied taking the test. The other thing is they have a small machine, a breathalyzer machine, that they will use out on the site. These aren't admissible anyway, and you don't have to take those either. Now, let's assume you've denied, you said I'm not going to do those things, or you have done them, and the officer arrests you, takes you back to the station. You are in custody. There is something called the Alabama Implied Consent Law that when you got your driver's license, you agreed to that Alabama Implied Consent Law, which basically says that now you have to take a breathalyzer. You can refuse to take that breathalyzer. And this breathalyzer is the one that will be admissible in a court of law in this case. You can refuse to take it. If you do, there are penalties, and we can talk about those, but let's just say that there are penalties. You can lose your license, for instance, on the first conviction or the first arrest up to 90 days. The thing you have to realize, if all they have is the belief that you have 0.08% in your bloodstream, that's the only evidence they're going to have to that effect. Possibly the field sobriety test comes into play. But if they're going to charge you with what's called A1 in the code section of having more than 0.08% or more, they have to have a breathalyzer in order to get a conviction.
Now, as a defense attorney defending individuals with DUIs, are you of the mindset and do you subscribe to the idea that other than providing that basic biographical information, if you have had a few drinks, you shouldn't perform or undergo any field sobriety tests, breathalyzers?
I have always told people, don't take their tests. I haven't had a thing to drink. I go out here now and they stop me and want me to take a breathalyzer. I will not take it. I don't trust machines. And again, it makes it more difficult to defend. The more you're giving them evidence, you are. And I realize there's an implied consent that you do that. But you're giving them evidence.
Do you find police officers are still conducting the field sobriety test as much as they used to, or are they relying upon the breathalyzer machine and the technology to sort of conclude whether or not they're going to make an arrest or not? And why would they do one versus the other or both of them?
Well, there is some case law to the effect that if you don't do the field sobriety test, you're not going to have what's needed, the probable cause to make the arrest or to remove them. And in fact, years ago, I've gotten some cases dismissed because they did not perform the field sobriety test for whatever reason. I think the officer said the traffic was so bad, I just didn't do it. The judge ended up dismissing the case because there was no reason to go forward with a breathalyzer at that point.
Now, what if you?
Can we take a break?
Sure. I want to talk about taking the breathalyzer and registering below 0.08 and whether or not you can be arrested when we come back.
We'll pick up right there. We'll step aside our final break of the evening. This time enough to get your question into us. Call, text, email. You can also find the firm of Hollis Wright if you'll search that term on Facebook, and on Twitter it's Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. Now, we often hear the phrase burden of proof when it comes to civil or criminal lawsuits. It's the level of proof that a plaintiff must meet to win their case. But these burdens change whether you're in a civil or a criminal court. So in this week's Legal 4-in-1, we're answering the question, who holds the burden of proof and what is the burden in the case? Let's start with civil cases. Civil cases are brought by a plaintiff who claims they have been injured by some way by a defendant. Because there is no chance of jail time, since the injury does not amount to a crime, the burden of proof is not as difficult as in criminal cases. The level of proof here is called preponderance of the evidence. In general terms, that means the plaintiff must prove that it is more likely true than not true that the defendant is responsible for the plaintiff's injuries. You've seen the scales of justice before. Both parties have to fill those scales up with evidence to support their position. If the plaintiff can fill his scale up with just a bit more evidence than the defendant, the plaintiff wins the civil case and is entitled to a verdict. Now, the stakes are much higher in a criminal case than that of a civil case. That's because a criminal defendant could lose his freedom or even his life if he's found guilty. So who holds the burden of proof in a criminal case? Well, the state does, because the defendant is being accused of breaking state law. The state has to prove beyond a reasonable doubt that the defendant is guilty. It's the heaviest burden in the justice system. The evidence has to be so convincing that the jury believes beyond any reasonable dispute the defendant is guilty. Probably guilty just isn't enough in these cases. The law requires the jury to find the defendant not guilty if there is any doubt at all. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Technology beginning to catch up with enforcement there. Welcome back in to the attorneys. Our final segment here, a few minutes remaining. Get those calls, texts, emails in to us. Carter?
Warren, as I indicated before we took a break, what if somebody agrees to submit to the on-scene breathalyzer and it comes back at a level below the legal limit of 0.08? Does that mean that they are free to go, or can they still be charged with a DUI and potentially still be convicted?
You can still be charged with a DUI. Now, the statute is that if you have a .02, if you're a commercial truck driver or a bus driver, the standard is lessened, so .02 for that. But you can still be charged. There's another way of charging you, which is just called driving under the influence. If the officer has observed you driving, possibly even as little as swerving a little bit toward the middle of the road, he can charge you with the second part of the DUI statute, just driving under the influence. Has nothing to do with how much blood alcohol content is in your bloodstream. Also, you can be charged if you're under if you have controlled substances of some type.
Yeah, do you see clients, or do you have many of those cases where they actually registered below .08 but were still charged because of some observational reason by the police officer? Is that
Absolutely.
fairly common?
Yes, it is very common, and got several cases right now that very thing. It is below point. In fact, they came in saying, "But I thought this was below the legal limit," but they didn't charge. And sometimes they'll charge them with both, which creates a nice argument for me, but they can do that, and they can also charge them with the second part of it, which has nothing to do with a number.
A question we have here, do I have to be driving in order to be charged with a DUI?
No. If you have control of the vehicle, I remember very recently representing a truck driver. He got tired, he'd eaten, he'd had a couple of beers, he said. He pulled off the road to rest. Suddenly a tap on the window, and he's soon charged with a DUI. All because, why? First of all, they can circumstantially show that you could have driven the vehicle, even though the officer didn't see him drive the vehicle. He can say that, well, you had the keys, you were in the driver's seat, you had the ability to operate that vehicle, and you are impaired, therefore a DUI.
We briefly touched upon the enhancement of punishment related to DUIs earlier in the show, and I want to talk more specifically about that now. Talk a little bit about the new sentencing guidelines that have come out. I believe there is an ignition interlock system. What is that?
Well, back in, I think it was 2012, Governor Bentley signed into law the particular act that created the ignition interlock system. And the criteria for implementing that judges use for implementing that is by statute if you are 0.15 or greater. Again, the legal limit is 0.08. So if you are 0.15 or greater, first of all, the penalties double. If it's your first, whatever the penalties were for a first-time DUI, double. Same for the second, third, on down. But also in that, there is a requirement that the judge order the defendant to buy or rent, or whatever the characterization is, the ignition interlock system. The client has to pay whatever costs are involved, and what that is a device that is placed inside your vehicle. Your vehicle will not start until you have blown and satisfied it that you are below the legal limit.
Is it subject to manipulation? I get you to blow for me in the.
That it has been, and there are some changes I understand are being made now to make that more difficult. But it's something that makes it extremely expensive, and it should be a deterrent to people driving.
How about if somebody is arrested and charged and convicted of a DUI with a child in the car? Are there enhancements in that regard?
That's a good point, because the same statute, the same penalties are if you have a child that's 14 or younger in the vehicle with you and you're charged with a DUI or convicted of a DUI, I should say, those same penalties will apply. The ignition interlock system has to be done. Penalties are doubled. Same thing.
Taking this one step further beyond DUIs in those tragic circumstances where an occupant or somebody else, an innocent victim in another vehicle, is injured or killed, What types of criminal charges can arise from that, and do you defend individuals that have been involved in those types of occurrences?
Yes, many times people will be charged with a vehicular homicide. And you also have if you've got a restaurant or a bar involved that served drinks to someone that was obviously intoxicated, they can be held liable for whatever damages are in that incident.
Yeah, Dave, we represented an individual operating a motorcycle several years ago that was T-boned at an intersection by a drunk driver that ran a red light. He left the scene of the accident. Of course, we handled the civil side of it, pursued civil damages directly against the drunk driver, but he was also charged criminally with, I believe, some type of criminal assault. I don't know whether it was first, second, or third degree, but he spent over 2 or 3 years in prison as a result of that incident. So obviously, when injured people are involved, people get killed as a result of somebody driving under the influence, the sentencing for those individuals can really be devastating.
Be severe.
As they should be.
As they should be, that's correct.
Yeah. How severe are the penalties for DUI, and kind of first time versus subsequent? What does that look like?
Well, the minimum fine on a first time DUI is $600. That does not include court costs. So there are several $100s in court costs. Usually it's about $400 in court costs that are added on to that. Wow. And that's the minimum. Mm-hmm. It can go up higher than that. You're facing 12 months in the county jail. That isn't something to be sneezed at. It's no fun being in a county jail. I know it's not prison.
Yeah.
Second time DUI, and of course it increases from there.
Yeah, from there on. We've got a couple of minutes remaining, but want to give both of you opportunity. Just a final thought from you for our viewers tonight.
Well, the thing that I would remind everybody is you have rights in this country, and I'm so grateful to be in Alabama, to be in the United States. Don't give consent to search unless somebody's got a warrant. You don't have to do that. You don't have to, and you'll have to decide if you're going to take a breathalyzer. I don't recommend it. That's your call. If you've been drinking, I certainly would not advise it. But realize that you do have rights, and the biggest thing is consult an attorney quickly. Don't sit and wait. The clock is ticking on a lot of your rights, particularly concerning a driver's license, if you don't get in touch with an attorney soon.
Carter?
Yeah, I think I would just go back to the concept of designated drivers are important. I know we hear drink responsibly if you're going to drink. I don't think anybody's suggesting that we should eliminate alcohol entirely. Some people may like that idea. But if you have 1 or 2 drinks or 1 or 2 beers, that's okay. But know your limits. Understand how much you can drink, if you've eaten, whether you haven't eaten, and just drink responsibly. Try and have a designated driver if you're going to be out with a group of people and you know you're going to be drinking. Because I think prevention is the key. Not putting yourself in that situation is the key, and will eliminate a whole lot of problems, and will eliminate you from having to see individuals like Warren Freeman.
Yeah, absolutely.
Having a plan. Appreciate it, gentlemen. Good job.
Thank you.
Helpful information. Thank you for being here. Thank you for joining us as well. We surely do appreciate it. We'll look for you next time right here on The Attorneys. Have a great week.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright.